All right. Well, I know we have a bunch of other people coming on, but I think I'm just going to get started here. Good morning, everyone. Thank you so much for joining our workshop Wednesday. We'll have one more in November, and that'll be our last one of the year. But if you want to save the date, that one's going to be November 12th at 11 a.m. And that's actually going to be a great one to kind of coincide with the one we're doing today. So on November 12th, I'm going to have Krista Hermance on, and she is an estate planning attorney. And she's actually going to go over the title of it is Protect the Deal, Protect the Legacy, Learn how to prevent the pitfalls that could cost your client thousands. So she's going to talk a lot about trust. And so I'm really, really excited to have her. If you guys don't know her, she's just absolutely amazing. And so we'll just do a really quick, try to keep it at 30 minutes Zoom call on that date. And before I introduce Kyle, I did kind of want to tell you guys another save the date. For those of you, or maybe some of you aren't involved with WIRE, which is our Women in Real Estate Ventura County, we have like 4 events a year. Men, you guys are all invited as well. We adopt 5 families every year for the holidays. And so we put on this big holiday party and gift exchange. And this year it's going to be on December 3rd at 4:30. It's going to be from 4:30 to 7. And we'll have it at Immigrant Sons Cafe at the Collection in Oxnard. And so it's just a super fun party, and all the funds go to the adoptive families. So we'll have a list and everything of all the gifts that we need to get for the kids and their families. And so if you want to join us, I think it's $25 is the ticket. So I'll definitely get more information out on that. If you're interested, just let me know. We are looking for sponsors too. So if you'd like to be a sponsor. And I think that's it for right now. I know that Kyle has a lot to talk about in a really short amount of time. So I'm going to introduce him. This is if you have not met him, this is my title officer, Kyle Johnson. And he's going to be talking about preventing probate problems before they derail your deal. So Kyle, thank you so much for joining us today.
Thanks for having me, and good to see everybody. A lot of familiar names up there. And yeah, probate is a pretty comprehensive topic, a lot to cover in 30 minutes. So I'm going to try to zoom through it and give you guys the best overview I can, just to get you comfortable with some of the terminology, some of the documents that you'd want to gather when you go to your listing appointment, or when a proposed seller says that they're either going through probate or have already concluded probate. And hopefully leave a little time for some questions, because I know there's going to be some. And this is a great meeting that is going to be the precursor to Krista talking next month, because how we're going to wrap this all up is, what is the best way to avoid probate? Having title to your property held in a trust. So this will be a really good segue into that next workshop Wednesday you have, Brenda. So let me share my screen a little bit. I have this form that Brenda can then share with you guys. Can everybody see it up there?
Yep.
Perfect. All right. So what is probate? So probate essentially is this court process by which a will is proved valid or invalid. So if someone has a will, let's validate that will and figure out what happens to their stuff. Or if there's no will, how is a court going to determine who's in charge of that person's stuff? So when a person dies, their estate has to go through probate. It's overseen by a particular section of court, probate court. And either a representative or an heir or a friend, or sometimes a professional fiduciary will be named as the responsible party to deal with the decedent's things. And what are some of the documents that you would be looking for as part of the transaction? So there's a number of documents, and look, guys, probate can go so many different ways. It will depend on how many heirs there are, if any. It'll depend on in how much agreement all of those heirs are with what actions to take for that person's real property. It'll depend on whether it requires court supervision or not. It'll depend on how much authority that person in charge of has. So every probate case will have its unique set of circumstances. What I recommend is when you go to your listing appointment, hopefully you have a prelim from us prior to going to your listing appointment so you are properly armed with facts about the property. And the person tells you that it was their brother, sisters, parents, someone's house, they've gone through probate, you know what questions to ask. So the first document that I'm going to share is called letters. Letters is the document the court will issue at the conclusion of probate. This document is going to name whose estate we're dealing with, and most importantly, who has the authority to deal with that person's estate. So when I screen share, can you guys see my mouse on there too?
I can't, no.
Oh man. All right. Well, on the top there, it'll say the estate of. Hopefully that's the decedent of the property. And there's different types of letters. So letters of testamentary, that's when someone has a will that has been validated. Letters of administration is when the person does not leave a will. So the court's going to determine who has the authority to deal with the property. Letters of administration with will annexed, that means that there was a will left, but the person who is named as the custodian of that estate can't or is no longer alive to serve. Or special administration. You don't see special administration too much, but that would mean that the estate is probably very complex and has its own unique set of circumstances. I've only seen a couple of those in my career doing this. And then towards the bottom, it'll say the court appoints somebody's name. That's the person that's going to sign your listing agreement, and that'll be the seller for the real property. Do they have full authority? Do they have limited authority? And based on this, it will determine whether you need court supervision or not. I'm sure a lot of people have heard that, right? This is a probate with court supervision. If the person has full authority, great. Usually they just need to contact the other heirs and issue a document I'll show you in a second. If they're only granted limited authority, that means that the court is going to have to review the particulars of the sale of the home, including the agents, commissions, sales price, what date you can close on. And then eventually the court is going to have to issue an order approving the sale of the property given all of the circumstances of the sale. So let's take a look at probate, the most typical type you'd see, where an heir is named as administrator of the estate or executor of the estate, and with more than one heir. So the next document the court is going to give the administrator or the executor of the estate is this notice of proposed action. So if there's more than one heir to an estate, everything that administrator or executor does, they have to get approval from all the other heirs of the estate, including the sale of real property. So once the court has named an administrator or executor, now they want to sell a home. They contact you, the listing agent, they're ready to sell. They have to issue this document, notice of proposed action, to all the other heirs with the particulars of the sale, sales price, agent, commission. All of the other heirs here either have to consent or object to whatever that action is. Ideally, if the family dynamics are right and everybody is in agreement as to what should happen with the property, everybody would sign this consent, nobody would object. In title, we will require to see this document. It usually will have a date of sale on here. Either everybody can consent and we don't have to adhere to that date. If we're either waiting for consents or they're just waiting out this timeline, title would want an email from that probate attorney on the expiration of that date saying, we just want to make sure nobody has objected to the sale. If they object, sometimes that's a longer process. It may require court supervision, or it may just be some small piece of information or the sales price or something that somebody's objecting to. But sometimes, right, family dynamics aren't right and someone doesn't want to sell the house, or they think they need to increase the listing price by $100,000, which probably not realistic, but this could hold it up. So ideally, we'd want to see consents and not have to wait out that timeline, or wait it out, and as long as nobody's objected, we're good to sell. The last document I want to show you is what is required for a court supervised sale when someone has limited authority, or in the case that somebody has objected and maybe the court has determined that that objection is not really a valid reason to object to sale of the property. The court will issue this order confirming sale. This is going to show that the sale is authorized by the court. It'll be signed by a clerk or a judge. It'll have the sale date. It'll have the sales price. It'll have the agents listed. And this is the document that would get recorded along with the close to show that the administrator who's signing the grant deed, who has signed your listing agreement, has had the approval of the court to do so. This is a general overview of probate and what documents that to look for. I know Brenda's mentioned it before, but when you guys go to a listing appointment or you know that probate's going to be involved in the sale, and if you're not super well versed or have much experience, please reach out to me. Please reach out to Brenda. I am never shy to contact sellers, to contact their probate attorneys, to let them know what it is we're looking for, the documents that we're going to need, or if they haven't conducted probate and need to, or if they're in the middle of probate, we can definitely get them on the right track and point them in the right direction. So, gosh, Ventura County, if most of you agents deal with real property in Ventura County, the probate court is actually pretty quick, couple months from the start of probate to the conclusion of it. The real headache's going to be the cost in which to do it. So last year, the average timeline in California to conclude probate was anywhere between 6 and 18 months, and the average cost was anywhere between like $20,000 and $30,000 to do. A lot of that will depend on the complexity of the estate, legal fees of the particular probate attorney you hire. We never recommend people try going at this process by themselves without the help of a probate attorney, unless they have a lot of experience in court proceedings. It's very complicated, and if you don't know what you're doing, it could really cost you. So we have, including Krista, we have a number of estate planning attorneys and probate attorneys that we can refer your clients to. So gosh, it's expensive and it's a lengthy process. How can we avoid having to do probate for real property? And we'll go through this list and we'll do it with the plans that have the most efficacy of how to do it. The number one way is trusts. Having the title to the property held in a trust. How does this avoid probate? Well, if any of you have your own trust agreement in place or estate planning documents, you know, the trust will say who the trustees are. In the event of incapacity or death, who the successor trustees are. If they can't serve, the next in line and the next in line. It'll clearly say who the beneficiaries are. It'll say who the property should go to. It'll say where the proceeds should be distributed to. So in the event that title is held in a trust, no matter what death or incapacity may arise, the trust agreement will cover that. And all at that point we need is either doctor's letters or a death certificate and escrow drafts and affidavit. It's a very quick and pretty easy process. The next one is how to hold title that includes right of survivability built into it. One of the ways is joint tenancy. So even if you don't have a trust in place or the seller doesn't have a trust in place and one of the joint tenants dies, the property gets transferred to the surviving joint tenant. It could be any number of people that can hold title as joint tenants. There could be 10 people that hold title as joint tenants. Here are some things of why joint tenancy is a bit flawed. The first is it does not cover incapacity. If any joint tenant at any time becomes either temporarily or permanently incapacitated, you have to go through another form of probate court where you seek a conservatorship for that person. Again, lengthy, costly. In the case where there's multiple joint tenants, if at any period of time that joint tenant transfers title to somebody else, transfers title into their trust, or changes the manner in which title is held at all, it's considered breaking the joint tenancy, and there's no more survivability built into it for any of the joint tenants. So it's pretty often that you'll see, friends, siblings, or just investors take title as joint tenants together, and then a couple years after the close of escrow, one decides they want their interest to be held in their trust or their LLC or whatever the case may be. The moment they record that deed, it severs the joint tenancy, and no matter what happens, incapacity or death to either one of those joint tenants, now there's no right of survivability built into it. So it is a bit flawed. The next one is community property with right of survivorship. You typically see that with spouses in the state of California. Again, if in the event that one spouse dies, the property goes to the surviving spouse. All you do is get a death certificate, escrow drafts, and affidavit. The one thing this does not cover is incapacity. So in the event there's no power of attorney in place and one of these spouses becomes incapacitated, you now have to go through probate and you have to seek a conservatorship for your spouse, or go to court and seek a spousal order of some sort. Lengthy, costly. The next one is, it's a vehicle that was pretty popular in the 90s, not so popular anymore. And there's no section of the probate code that has changed more, in my experience doing title, than this particular section. And these are called transfer on death deeds. Transfer on death deed is a document you would record on a property. Usually it's people that hold title by themselves as individuals. They don't have a trust. There's no joint tenant. There's no other co-owner. There's one person in title. They record this document that says, in the event of my death, I'd like the property to go to this person. The reason why these don't work so much anymore is that it seems every few years the probate code changes, and the type of information that's supposed to be contained on the document, the timeline between which it was executed and recorded, changes all so often. So I got to tell you, maybe 7 out of 10 of these transfer on death deeds, when we go to review them, don't add up to the current probate code, and they have to go through probate with these anyway. So it's a cheap and easy vehicle as a temporary way to ensure that if something happens to you, the property could go to a beneficiary, but it's definitely not a good substitute for having a trust. I tell people all the time, even if you're 18 years old, this is the only asset you own, and period, I still recommend having a trust and having title held in a trust to make sure that something happens to the property in the event of your incapacity or death, and to save your loved ones from time and money wasted to take care of it. And then the last one, which typically only covers vacant land transactions, is this affidavit regarding property of small value. So in the event that there is a death of someone that owns a property where the value of it is less than $60,000, you can record this affidavit. There's a process in which the probate court, all they have to do is get it's called a probate referee to do a appraisal of the property, and as long as they confirm that its value is under a particular dollar amount, they allow you to record an affidavit, and the property goes to an heir. You get to skip the whole probate process. But again, a low dollar amount. So this isn't covering single family homes. This isn't covering much except for probably vacant land transactions. And that's it. I know I zoomed through this. Brenda will share this with you, but here's some common list of words and definitions that you'll hear regarding probate terminology. And that's it. I know that seemed very rushed, but we only have 30 minutes, and there's probably a bunch of questions. So if anybody's raised their hand, or if anybody wants to ask any questions over the next 10 minutes or so, we can hopefully address them all.
Any questions, anyone? If you want to put it in the chat, feel free. Please ask questions. Usually we do have a bunch of questions when it comes to probate.
Yeah, it feels sometimes like a law class, right? We just zoom through it in about 15 minutes. So probably everybody's letting it all sink in and process a little bit.
The one thing I like, though, about the way you explain, no matter what it is really on these workshops, is that I feel like you make it so easy to really understand. So, I mean, they're complicated topics.
There is one thing I didn't touch on, maybe while people are thinking of questions, is let's say the person has a trust in place, but title is not held in the trust for one reason or another. Either they never got around to transferring the property into their trust, or, like probably some of you have seen, lenders won't lend to a trust, and so as part of people doing refinances, they require the property come out of the trust. You do the refinance, and you're supposed to record a deed putting the property back into the trust, but sometimes a title company will fail to require that and record that document putting the title back into the trust. There is a rushed and cheaper version of probate, and it's called a Hegstad petition. And what the heirs can do, or a spouse with an incapacitated spouse or deceased spouse, is you can petition to the court and say, hey, this property is listed as an asset in our trust, although the title was not held in the trust. And we are requesting that the court confirm that this should be considered a trust asset. The court will issue an order and they will say, even though it was held as John Doe and Jane Doe, husband and wife, we are going to determine that this should be considered an asset of the trust. We record that order, and now you can treat it like any other piece of real property. That title was held in the trust. You follow the dictates of the trust, you have the successor trustee sign, and you follow whatever the trust says. So in some cases, this can be a cheaper, quicker alternative than going through full probate in the event that the person already has estate planning documents in place, but just never put the title into the trust.
Any questions? Have you guys had any transactions that, you know, maybe you want to share where there was issues or challenges or?
Or we can do title questions that have nothing to do with probate.
We can do that too. You got Kyle's full attention. Any transactions that you guys have right now? You have title questions. I also want to say that, you know, it doesn't really matter. You know, I know a lot of times when it comes to your buyers that you don't get to choose title. And so even if you guys have prelims that are from another company and you don't know that company or you don't have a relationship with the rep, we're always happy to review those for you and answer any questions you might have or anything that might be alarming. We'll go ahead and review those. So no questions? I'm really surprised. This is usually one of the workshops where we have a lot of questions or things come up. So anyone? Margaret? Oh.
Oh, I don't have a question. I just was going to say I'm thankful to Kyle for files that he's helped me on. We have one that isn't quite to the end of life, but between power of attorney, advice on power of attorney, and someone who becomes a successor trustee once the person passes away, it was really helpful to have that information. So I just wanted to thank you for that.
Oh, you're most welcome, Margaret. Absolutely.
You know, I also want to just remind you guys that this is why you have a team. So I know sometimes I get agents that are really like, they feel like they have to know everything, you know, and that's why you have us on the title end is so we can help. And so you don't have to be the expert, because I know and agents tell me all the time, you know, that Kyle is one of the title officers that he will talk to, you know, he'll run through, you know, topics with you, with your buyers, with your sellers. And they're like, I've never had a title officer actually get on the phone with my clients and be open to doing that. So that's one amazing thing about Kyle and Choosing Consumers Title is, you know, we will go above and beyond to, you know, kind of help you guys out with that kind of thing. So we are always here. It doesn't look like we are going to have any questions, which I'm still so surprised, but just a friendly reminder. I know some of you guys showed up late. And so I did record this if you would like the recording. And then also we have the workshop Wednesday on November 12th with Krista. So like Kyle said, this is a really good segue into that workshop, which will be with Krista Hermance. She's a estate planning attorney, and we'll be talking about the importance of trust and saving your deals and, you know, all that. So we're really excited for that. So
I added my email into the chat. So if anybody does think of questions after we conclude here or anything else you think I can help you with, just let me know.
Yeah. And I just want to also say really quick before we end that, you know, anything that we can do, you know, we hold these workshops and classes in your offices and stuff like that because we want to earn your business. So if there's anything that we can do, you know, I brainstorm a lot with agents in regards to farming and marketing and just how to do things differently, maybe farm within your farms. You know, I would love to help with that. So anything that we can do, please let us know. And thank you guys so much for attending today. We really appreciate it.
Thank you, Kyle. Thank you, Brenda.
Thank you guys for your time.
Welcome.
Of course.
Everybody have a good day.
Thanks, Kyle, so much. Appreciate it.
Bye.
Bye, everyone. Thank you. Stay cool out there.